Welcome back to 99rights_online. Ever wonder which law reigns supreme when rules collide? Join us as we map the US legal food chain. First and foremost, at the apex is the United States Constitution. It's the supreme law under the Supremacy Clause of Article 6 of the Constitution. So, what is the Supremacy Clause of Article 6 of the Constitution, you ask? Article 6, or known by the Roman numerals as VI, cements the Constitution's authority by validating prior federal debts, declaring federal law supreme over state law, and requiring office holders to swear allegiance, without imposing any religious test, which means no law, federal or local, can override it. How did that happen? Well, back in 1803, Marbury v. Madison cemented judicial review, giving courts the power to strike down unconstitutional acts. It is quoted, "It is emphatically the province and duty of the judicial department to say what the law is." Chief Justice John Marshall, Marbury v. Madison, 1803. Next up. Federal statutes and treaties. Congress writes statutes that apply nationwide, and treaties ratified by the Senate bind us all. Executive agencies, like the EPA or FDA, then craft regulations under the Administrative Procedure Act to enforce those laws. Then come state constitutions and statutes. States can't pass laws that conflict with federal law, but they fill in gaps on everything from education policy to environmental rules. Think New York's strict data privacy laws versus federal protections. Local ordinances sit below state law. City councils and counties pass parking rules, zoning codes, or even noise ordinances. But if a city's plastic bag ban clashes with state law, it's out of luck. Finally, judicial decisions. When no statute applies, courts interpret existing laws and set common law precedents. These decisions fill the blanks and can even reshape how laws function on the ground. But what about how this impacts you? Well, businesses juggle multi-layer compliance. This can lead to an increase in costs, but it also ensures uniformity. We also have states giving pushback, like sanctuary cities resisting federal immigration orders, passing laws to bar state agencies from implementing environmental, social, and governance, ESG, investment guidelines promoted by federal executive orders, or even refusing to expand Medicaid under the Affordable Care Act, foregoing billions in federal dollars to assert state sovereignty. Throughout it all, courts mediate conflicts, but debates rage over judicial activism versus strict textualism. So, what is judicial activism? It is the practice of interpreting constitutional or statutory text in light of evolving societal needs. And what about strict textualism? Well, that means the approach of limiting interpretation to the text's original public meaning. This stands at opposite ends of the judicial spectrum, and debates rage over which method courts should follow. What do you think? When should judges adapt the law to modern realities rather than confine themselves to its original wording? Comment below. So that's your crash course on the US legal hierarchy. Thanks for watching. Stay empowered. Know the law. Know your rights. Because you can't know your rights without knowing the law.
But I'm rising up, I'm breaking free, chasing dreams, just wait and see. From the ashes I ignite flame, education's my part that I'll change the game with. Every lesson learned to find my way, turn creative power, come what may. I wanna be part of something bigger, a force or change, a light that's a trigger. When I walk in the court, stand tall and proud for every voice unheard. I'll shout it out.